Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today is the day I earned that subscription. For today's story, we are talking about a Virginia Tech soccer player who has been suing and just been given permission to sue for allegedly being benched because she refused to kneel as part of her activities. So kneeling or not kneeling is obviously a controversy in sports. Some people believe the kneeling is good. Some people believe the kneeling is bad. But at least according to this lawsuit, this student did not want to kneel and was punished for the not kneeling. Incidentally, Virginia Tech is a public school. So they were discriminating against her based on speech or based on her viewpoint, right? So to the extent kneeling expresses a viewpoint, which one thing it does, she didn't want to participate. And so a state school is benching her for refusing to kneel, or so the lawsuit says. So we're going to cover this and review a little bit about this. What is happening at these universities? Let's get started with this. A judge has ruled that a former Virginia Tech women's soccer player can continue her lawsuit against her former coach after she was allegedly benched and pressured to leave the team for declining to kneel during a pre-game social justice demonstration. Kirsten Henning, who was a midfielder defender for the Hokies from 2018 to 2020, has sued the coach on First Amendment grounds, which the federal judge has announced can proceed to trial. So we've made it past an initial motion to dismiss. First Amendment speech, First Amendment retaliation, retaliation against speech, retaliation for viewpoint, for not expressing certain viewpoints at a public school. This presents a problem. Henning alleges that the coach was not a fan of her political views and that she often differed from her teammates on social justice issues during the height of Black Lives Matter. Henning, the soccer player, further explained in the lawsuit that while she supports social justice and believes that Black Lives Matter, she does not support the BLM organization, which understood, at least according to her, because its tactics and core tenets of its mission statements, including defunding the police. Yeah, and also the fact that the organization is just straight up communist. So like when you say, do you support Black Lives Matter? Well, that's one of the things. Like, do you support the cause or the organization? So she might support the cause to some degree, but she doesn't support the organization. The organization stands for many, many political things, which some people might not support. And she'd like to not express those views through her symbolic speech. She'd like to not kneel, which is symbolic speech, and she'd like to not express that view. And because they said, well, because you won't express that view, right? They're not punishing people who kneel, so they're not punishing people who express the opposite view. But because you won't express the view we want, we're going to discriminate against you. You can't do that if you're the government. According to the lawsuit, after the soccer player declined to kneel during a reading of a unity statement before a game against the University of Virginia on September the 12th, she said the coach verbally attacked her at halftime, claiming that she was bitching and moaning while jabbing a finger in her face. The coach continued to berate her until he benched her and ultimately made things so intolerable that she felt compelled to quit the team, according to the lawsuit. Henning, the soccer player, who had been a major on-field contributor for 2 years prior to 2020 season, and asserts the coach removed her from the starting lineup for her next 2 games and dramatically reduced her playing time in those games because she had engaged in protected First Amendment activity. As a result, Henning resigned from the team after a 3rd game of the season, according to the judge's recent ruling. So that seems to be what's true, at least on a preliminary standard. Henning's time on the field dropped off following the incident, according to the judge's ruling. As a freshman, Henning averaged 76 minutes of playtime. As a sophomore, 88. That's a lot of playtime in a game that's 90 minutes long. But during the Clemson game, go Tigers, the next game after the kneeling incident, Henning only played 29 minutes, and at the UNC game, just 5. So yeah, that might be suggestive of some sort of retaliatory conduct, all right? So she's normally playing 76 minutes, 88 minutes, basically playing the game. But after the kneeling incident or lack thereof, she plays 29 minutes. She plays 5 minutes. This is suggestive of retaliation for protected First Amendment activity by a governmental actor. So, could be a problem. The coach, who argued that 2 other players who declined to kneel did not face reduced playing time, moved to dismiss. Well, maybe, maybe not, but that's an issue for trial, right? Or at least an issue not for summary judgment, right? So, like, if all her facts are true, the fact that she was discriminated against, just because you didn't discriminate against others doesn't mean that she wasn't discriminated against. So, the judge says ultimately the coach may convince a jury the coaching decision was based solely on poor play, but of course that's a pure fact. Was it because of play or was it because of other reasons? But the court, viewing the evidence in the light most favorable to the soccer player, which of course you're required to do at this stage, cannot reach that conclusion as a matter of law. Yeah, because the issue is, what was the reason? Maybe the other players were discriminated against, maybe not. Maybe they're discriminated against less, maybe not at all. Maybe the reason that she was benched was because due to play, maybe not. But these are the issues of fact. And we are on a preliminary stage. So on a preliminary stage, we're going to read everything in light of her arguments, and it seems like she potentially got it. While the U.S. Supreme Court and the Fourth Circuit may not have addressed the novel factual circumstances, which would potentially go to qualified immunity, I know we're all looking for that in the future. That is, a college coach allegedly retaliating against a player for refusing to kneel with her coaches and teammates in support of perceived unity and social justice. The core constitutional principle is both clearly established and fundamental. So the judge thinks maybe qualified immunity, we can get past that. Thus, that brings us to the end of the story of Henning, a college soccer player who was playing lots of games and lots of minutes at those games. But after refusing to literally bend the knee, she apparently was punished by her coach by not giving playing time, and apparently was badgered and harassed so much for her political views that she felt compelled to resign. Well, now she has sued, claiming discrimination based on protected First Amendment activity, discrimination on the basis of viewpoint by a governmental actor, namely the coach of her team. Of course, qualified immunity is always a problem, but this is First Amendment speech. And fortunately, due to cases even at the Supreme Court dealing with a college football coach who was allowed to kneel for prayer, for example, there is some case law that's parallel. But whatever might be true of qualified immunity is another problem for another day. This lawsuit is allowed to continue for the moment, so hopefully Henning will get some justice in the courtroom, just as she did when she was allowed to play for her team. At least for a moment, that brings us to the end of discussion of this case.